Hello, everybody. Oh, yes, ladies and gentlemen, boys and girls, women and children of all ages, and these them, zers, they, them, they, them, zers, zays, all those people, welcome. We're going to do some reading from Modern American Remedies this evening. I'm all dressed up and know where to go. Here we go, folks. Alrighty. So we are now repairing the consequences of past wrongful conduct. Remember last time we were looking to enjoin future wrongs, potential speculative harms with injunctions. Now we're trying to use injunctive relief to repair the consequences of past wrongs. Our first case is Forster v. Boss, an Eighth Circuit case from 1996. Before Richard S. Arnold, Chief Judge, Woolman, Circuit Judge, and Cornerman, District Judge. Arnold, the Chief Judge, wrote the opinion. This case arises out of the sale of property fronting on the Lake of the Ozarks in Missouri. I've been there. It's redneck as hell. The plaintiffs are the buyers of the property, James D. Forster and Joanne Forster. The defendants are the sellers, Patrick W. Boss and Janet L. Boss. The district court awarded plaintiffs both damages for fraud and breach of contract and injunctive relief. Defendants appeal, arguing that plaintiffs are receiving what amounts to a double recovery, an injunction that makes them whole, plus damages to compensate them for the loss of the very rights the injunction has guaranteed. We agree with this contention in part, and accordingly affirm in part, reverse in part, and remand for further proceedings. I'm guessing since it's fraud, they're going to allow them to have some damages because you fucking committed fraud. When defendants, the bosses, it's a good last name to have, hi, we're the bosses, agreed to sell the property to the Foresters, they represented that the Foresters could obtain a permit for a boat dock in front of their newly acquired property. In fact, unknown to the Foresters, the sellers had a boat dock permit of their own that made it impossible for the Foresters to obtain the permit they had been promised. The defendants do not contest the finding made below that they were guilty of fraud in this respect, and in fact, when the plaintiffs applied to the Union Electric Company, which created the lake and has the right to grant all permits, for a permit, the application was denied on the ground that the sellers, the defendants, already had a conflicting permit. To compensate the plaintiffs for this fraud, the jury awarded $12,250 in compensatory damage and $10,000 in punitive damages. Being like, you try to sell them something that you don't fucking have the rights to sell them. Bad bosses. The other claim for damages on which the plaintiffs prevailed had to do with a swim dock. When the property was sold, defendants promised that they would remove their swim dock from the front of the transferred property. They did not keep this promise. The jury awarded $2,500 in compensatory damages to the plaintiffs on the account of this breach of contract. The major issue on appeal arises because damages were not the only relief secured by the plaintiffs. They also got a permanent injunction ordering defendants to remove the offending swim dock. In addition, and most importantly, they got their boat dock permit from Union Electric. Union was a party defendant in the district court. It took no active part in the trial except to enter a stipulation agreeing that if the court should hold plaintiffs entitled to a permit under their current contract with defendants, Union would grant the permit to plaintiffs and revoke the permit previously granted to the defendants. This in fact occurred, so plaintiffs now have their permit and the defendants lost their permit. No future permit may be granted to defendants that would interfere with the plaintiff's rights. In this situation, defendants argue that the injunction has made plaintiffs whole. They have both the swim dock removed and their boat dock permit. Thus, the property transferred to them has exactly the characteristics defendants agreed it would have. It has a boat dock permit attached to it, and it is not encumbered by the defendant's old swim dock. If plaintiffs also receive as damages money to compensate them for the difference in value of the property as promised and the value of the property received, they have received a double recovery. Plaintiffs have, in effect, received not only damages for fraud and breach of contract, but also specific performance. They have both money and the property, and are in a better position than they would have been in had there been no fraud or breach of contract in the first place. Well, the court, for some reason, finds this argument compelling. Plaintiffs point out that under Missouri law, the measure of damages for fraud in connection with the sale of land, is the difference between the value of the land on the date of sale as represented and the value of the land on the date of sale as actually conveyed. The sale took place in 91. At that time, according to the jury, the land as represented was worth $12,250, more than the land it was conveyed. Nothing that happened thereafter, for example, the injunction that guaranteed the plaintiffs their boat dock permit, can change those facts. We understand the arguments, but find it too simplistic. If the argument were accepted, the entry of an injunction or the obtaining of a boat dock permit in some other way would be wholly irrelevant to the recovery of the damages, even though one or the other of these events occurred on the day immediately following the sale. This does not make sense. It is true, of course, that the lapse of time was greater than 1 day here, about 3 years, in fact. It is entirely possible that plaintiffs sustained some sort of damage because they had to wait for the complete fulfillment of the terms of the sale. The case, however, was not tried on that theory, and there is no evidence in the record on which damages of this interim kind can be calculated. We cannot escape the proposition that the injunction has made plaintiffs whole in the very respects which they were seeking damages. To allow them to keep both the compensatory damages and the injunction would be a double recovery. We conclude that the case must be remanded for further proceedings. On remand, it will be up to plaintiffs to elect which remedy they want. They can either choose the compensatory damages or the injunction. We think, however, that they should be allowed to retain $10,000 award of punitive damages in any event. Defendants' conduct in this case was abusive, and they do not argue on appeal that the award of punitive damages was not based on sufficient evidence of their misconduct. Punitive damages are not designed to compensate anybody. They're designed to deter baddies from doing bad stuff. The award of punitive damages, therefore, is not duplicative of the relief contained in the injunction. If it is necessary under Missouri law for some compensatory damages to be awarded in order to support the award of punitive damages, the district court is instructed to award the plaintiffs compensatory damages of $1 on their fraud claim and then give $10,000 in punitives. To the extent that it holds defendants liable, this judgment is affirmed. To the extent that it allows plaintiffs to receive both compensatory damages and injunctive relief, the judgment is reversed. The case is remanded for further proceedings consistent with our opinion. Cornerman, district judge, concurring. He says, I concur. Most respectfully, I write separately only to express my opinion that plaintiffs elected a remedy. They sought and received an injunction and the fruits of it, the boat dock permit. It would be unjust for plaintiffs to receive the dock permit as they already have, keep it, and also recover damages for the claimed loss of the dock permit. My concern is that if plaintiffs are simply allowed to give up the injunction, our decision may have little practical benefit for defendants who will already have lost the permit and will still owe the monetary damages. It may be that the dock permit cannot be retrieved by defendants despite the lifting of the injunction. In the alternative, I would have the district court determine if plaintiffs have made the election to mandate, the mandate being that plaintiffs are not allowed to receive and retain a dock permit as well as the $12,250. End of that case. Welcome to Missouri. Welcome to Lake of the Ozarks. Welcome to the Suck. We're already moving on to case 2 today. Modern American Remedies. Remedy. Winston Resource Corporation versus Minnesota Mining and Manufacturing Co. 9th Circuit, 1965 case. Before Jertberg, Browning, and Foley. Browning, the circuit court judge, wrote the opinion. All right. The Minicom division of the Minnesota Mining and Manufacturing Company developed an improved precision tape recorder and reproducer. That's neat. Somewhat later, Winston Research Corporation developed a similar machine. Minicom alleged the Winston machine was developed by former employees of Minicom, including Johnson and Tobias, by using confidential information which they had acquired while working on the Minicom machine, and they sued for damages and for an injunction. The district court granted Minicom an injunction but denied damages. Both sides appealed. Part 1. For some users of precision tape recorders slash reproducers, the time interval between coded signals must be recorded and reproduced with great accuracy. Minicom developed an improved solution to this problem. In May of 1962, when Minicom had substantially completed the research phase of its program and was beginning the development of a production prototype, Johnson, who was in charge of Minicom's program, left Minicom's employment. That's sus. He joined Tobias, who had previously been discharged as Minicom's sales manager, in forming the Winston Research Corporation. In late 1962, Winston contracted with the government to develop a precision tape recorder. Winston hired many of the technicians who had participated in the development of the Minicom machine to work on the design and development of the Winston machine. In approximately 14 months, Winston completed the machine, having the same low time displacement error as the Minicom machine. Section 3. I guess we skipped 2. These books are edited to shit. The district court found and Winston concedes that Johnston and the other former Minicom employees based Winston's development program upon the same approach to the problem of achieving a low time displacement error as they had pursued in developing the Minicom machine. The district court further found that this general approach was not a trade secret of Minicom's. Finally, the district court found that the particular embodiment of these general concepts in the Minicom machine was Minicom's trade secret and had been improperly utilized by the former Minicom employees in developing the Winston machine. Section 4. The district court enjoined Winston Research Corporation, Johnson, and Tobias from disclosing or using Minicom's trade secrets in any manner for a period of 2 years from the date of the judgment, March 1, 1964. The court also required the assignment of certain patent applications to Minicom. No damages were awarded. Minicom argues that the injunction should have been permanent or at least for a substantially longer period of time. Winston contends that no injunctive relief was appropriate. Minicom was, of course, entitled to protection of its trade secrets for as long as they remained secret. The district court's decision to limit the duration of injunctive relief was necessarily premised upon a determination that Minicom's trade secrets would shortly be fully disclosed through no fault of Winston as a result of the public announcement, demonstration, and sales and deliveries of the Minicom machines. Minicom has not seriously challenged this implicit finding, and we think the record fully supports it. Basically, you have this top secret fucking machine that's your old trade secret, and now you can be selling it at Walmart. Well, then literally any jackass on the street can go into Walmart and buy the machine and take it apart and figure out how it works. So, no dice. Minicom argues that notwithstanding public disclosure subsequent to its former employees' breach of faith, Minicom was entitled to a permanent injunction under the Shelmer Rule. Winston responds that under the competing Colmer Rule, public disclosure of Minicom's trade secrets would end the obligation of Minicom's former employees to maintain the information in confidence, and that neither the employees nor their privies may be enjoined beyond the date of disclosure. Like I said, once it goes to Walmart, you can buy it and dissect it. No trade secret. It's out in public. Thus, Winston's argument would bar any injunction at all once there was a public disclosure, and Minicom's argument would require an injunction in perpetuity without regards to any public disclosure. The district court rejected both extremes and granted an injunction for the period which it concluded would be sufficient both to deny Watson unjust enrichment and to protect Minicom's from injury from the wrongful disclosure and use of Minicom's trade secrets by former employees prior to public disclosure. We think the district court's approach was sound. A permanent injunction would subvert the public interest in allowing technical employees to make full use of their knowledge and skill, and in fostering research and development. On the other hand, denial of any injunction at all would leave the faithless employee unpunished, where, as here, no damages were awarded, and he and his new employer would retain the benefit of a head start over legitimate competitors who did not have access to trade secrets until they were publicly disclosed. By enjoining the use of the trade secrets for the approximate period it would require a legitimate Minicom competitor to develop a successful machine after public disclosure of the secret information, the district court denied the employees any advantage from their faithlessness, placed Minicom in the position it would have occupied if the breach of confidence had never occurred prior to the public's disclosure, and imposed a minimum restraint consistent with the relations of these objectives upon the utilization of the employee's skills. This sounds like a good decision. Minicom argues that in any event, a 2-year injunction from March 164 was not sufficient to overcome the wrongful advantage obtained by Winston. Minicom points out that 4 years were required to develop its machine, whereas Winston developed the machine in 14 months. For this reason, and because the injunction was stayed for a time, Minicom argues that injunctive relief should be granted for at least 3 years from the completion of the appellate review. As we have noted, the appropriate injunctive period is that which competitors would require after public disclosure to develop a competitive machine. The time, 14 months, which Winston in fact took with the aid of the very disclosure and use complained of by Minicom, would seem a fair measure of the proper period. The district court granted an injunction for a somewhat longer period, presumably because Minicom machine was built in such a way as to require some time for persons unfamiliar with it to determine its details of construction and to compensate for the delay which Minicom encountered in the final stage of its development program because Winston had hired away Minicom's key personnel. Whether extension of the injunctive relief period for the latter reason was proper, we need not decide, for Winston is not raised this question. We think it was proper to make the injunction period run from the date of judgment, since the public disclosure occurred at about that time. Minicom argues that the district court should have awarded money damages as well as injunctive relief. We think the district court acted well within its discretion in declining to do so. Since Winston sold none of its machines, it had no past profits to disgorge. The evidence as to possible future profits was at best highly speculative. To enjoin future sales and at the same time make an award based upon future profits from the prohibited sales would result in duplicating the inconsistent relief, and the choice which the district court made between these mutually exclusive alternatives was not an unreasonable one. There was evidence that Winston would probably sell its machine and realize profits after the injunction expired. But these sales and profits, as we have seen, would not be tainted by breach of confidence, since Winston could not by that time have developed its machine from publicly, or it could have rather, developed its machine from publicly disclosed information. We have examined the other bases upon which Minicom sought damages and are satisfied that they were either too remote or too speculative, or that the injunction made Minicom as nearly as whole as possible. Minicom argues that Winston gained a wide variety of advantages from the improper use of Minicom's trade secrets, such as obtaining financing for a development program, securing a government contract, shortening development program, reducing development costs. There is an obvious difficulty in assigning a dollar value to such matters. The 2-year injunction deprived Winston of any benefit it might have gained from these advantages and shielded Minicom from any potential harm from Winston's competition, which these advantages may have rendered unfair. Minicom suggests that by hiring away Minicom's skilled employees, Winston hired Minicom's development program and increased its cost. But, as we have noted, the district court expressly considered this delay and extended the period of the injunction for an equivalent period. Therefore, the judgment below is affirmed. Good call. I like that fucking case. Good job, court. Good fucking job, court. We just freaking have a standard of justice that applies and keep applying it. Good for you, bro. Slay, queen, slay. All right. We're on to the last case for today. Not that long. Not long. It is called Bailey versus Proctor. It is a First Circuit decision of 1947. All right. Bailey v. Proctor. Aldred Investment Trust was a mutual fund organized before the Investment Company Act of 1940. Its structure was typical of the abuses that led to the act. Voting control of the trust was held by the owners of $150K in stock. The holders of $6 million in debutantes proved most of the capital. The debutant, or sorry, not debutant, debenture. Sorry, my bad. That a debenture is like a bond or a promissory note. It is a promise to pay a fixed sum of money, usually on a date far in the future, and to pay periodic interest until the principal is paid. Debenture holders are fixed income investors, typically interested in a safe and steady return. The abuse in this capital structure is in its uneven and misleading distribution of risk and reward. If the trust goes broke, the stockholders can lose no more than $150,000. The debenture holders can lose $6 million. But if the trust does well, the debenture holders only get their interest. All the speculative profit goes to stockholders. Their profits can be enormous as a percentage of the investment because the $6 million invested by the debenture holders is working for the stockholders. For example, the debenture holders are promised a 6% interest, and the trust earns 8%. The extra 2% of $6 million is $120K. For the stockholders, that's an annual return of 80% of interest, or 80% of return on investment. If the trust invests in speculative stocks and doubles its value, the debenture holders get only 6%. But that $6 million profit is a 4,000% return for the stockholders. Consequently, the controlling stockholders have great incentive to take risks with the debenture holders' money. The debenture holders are limited to their 6% return, but they don't get the safety they were seeking. On the other hand, 6% was considerably above market interest rates all through the 1930s and 1940s. Great Depression. Remember that? Yep. Stock market was down. The Aldred Trust became insolvent. Well, there you go. And the control group was caught in fraud and self-dealing. For these reasons, a receiver was appointed at the request of the Securities and Exchange Commission, the SEC. A receiver is a court-appointed officer who takes possession and control of property and manages it under judicial supervision, pending the result of the litigation. The Court of Appeals approved the appointment of the receiver, Alfred Investor Trust, in a case from Alfred Trust called versus SEC, First Circuit, 1945. The year the war broke out. The year Pearl Harbor got bombed. My note's 42. 45. So the year we stormed the beach in Normandy. My bad. The original control group was led by a man named Hanlon. Bailey's group bought out Hanlon's group, and an enormous increase in the value of a racetrack investment made the trust solvent again. That's odd. But the district court ordered the receiver to liquidate the trust. Bailey appealed, arguing that because the trust was no longer insolvent and because those responsible for the fraud were no longer associated with the trust, both reasons for the receivership had been eliminated. Bailey also argued that the court had no power to order the liquidation in any event. This case is now before Magritter, Mahoney, and Woodbury, circuit court judges for the First Circuit. Mahoney writing the opinion. Appellant's first argument is that the district court lacked jurisdiction to liquidate the trust. In our view, the jurisdiction of the district court to act in terminating the receivership by ordering liquidation is dependent upon the jurisdiction existing at the time of the receivership was commenced. At that time, the trust was insolvent, and the officer trustees were guilty of, quote, gross abuse of the trust, close quote. We then upheld the district court's decree appointing receivers as being within the court's general equity powers. Admittedly, however, at the time of the appeal, the emphasis was on the power to appoint a receiver rather than the power to order liquidation as the end of the receivership. Therefore, rather than resting our present decision on the narrower ground of the law of the case, we now hold that a court of equity has inherent power to appoint a receiver to liquidate a corporation or invested trust where fraud, mismanagement, or abuse of trust is present, whether or not insolvency is likewise present. The question now presented to us is whether or not the district court has lost that power by reason of intervening solvency and the removal of the officer trustees guilty of abuse of trust and the impossibility of their now resuming such a control of the trust due to the transfer of the controlling shares to present appellants. In the first place, we do not believe that the perhaps temporary solvency of the trust would necessarily affect the power of the court supervising the receivership. Other grounds for the appointment of a receiver having been present, the court's jurisdiction is not defeated by the supervening solvency. Since a receivership may be inaugurated for a solvent corporation, solvency, especially where it may be of a transient nature, does not terminate jurisdiction to continue the receivership on the grounds other than insolvency. Moreover, we believe that the jurisdiction existing at the time of creation of the receivership is a continuing jurisdiction, and the questions of present solvency and removal from control of the offending officers and trustees pertain not only to jurisdiction, but to the propriety of the exercise of such jurisdiction. Once having properly assumed jurisdiction of a corporation or trust by appointing receivers under its general equity power, a court should not terminate its supervision until or unless it becomes satisfied that equity has been done to all those whose interests the court had originally been asked to protect. The court, upon examination of the plans for reorganization, found that none was fair and feasible, and consequently accepted liquidation as the only other alternative. The question before us is whether we can say that the court below abused its discretion in failing to vest control in the present common shareholders with the terms of the trust and the capital structure unchanged. In considering the propriety of the order decreeing liquidation, it must be remembered that reorganization of this trust was considered, at least by the Securities and Exchange Commission, and undoubtedly by the court, a necessary prelude to any termination of the receivership other than by liquidation. Appellants at least recognized the advisability of a reorganization in their final petition before the district court. Ordinarily, it is said that liquidation being a drastic remedy will only be decreed in an extraordinary case or when special and peculiar circumstances exist. Unfortunately, the district court did not furnish us with an opinion in which it indicated the grounds for the exercise of this discretion. However, from the record, we are able to garner facts which seem to support the manner in which such discretion was exercised. Since 1937, Aldred Trust assets have had a value substantially less than the principal amount of the outstanding debentures. During the years 1940 through 43, the earnings of the trust were substantially insufficient to meet the interest charges on those debentures. Only as a result of the successful outcome of a highly speculative venture undertaken by Hanlon has the trust been able to get its head out of water during the receivership. Temporary solvency was brought about by the sale of the Eastern Racing Association stock at a tremendous profit. Due to a post-war stock market inflation, the other portfolio assets nearly doubled in value, but were still less than the face amount of the outstanding debentures. The vagaries of the stock market are familiar to all of us. There seemed to be doubt also as to the ability of the future for any portfolio to earn these interest requirements except by resort to speculative securities with the hope of capital appreciation. The SEC indicated that the Aldred Trust security structure embodied the evils which led to the enactment of the Investment Company Act of 1940. The free stock, representing only a small investment and often no equity, controlled the operations, policies, and management of the almost $6 million investment of the debenture holders. The inability to earn interest requirements induces the controlling shareholders to engage in capital appreciation investments or in speculative ventures to ensure them a profit in one way or the other. Hanlon's activities in the Eastern Racing Association stock. The present holders of the free stock, the appellants here, purchased control of Aldred, which has $5,900,000 principal amount of debentures for $150,000. Their equity at present shows an appreciation of some $2,500,000 as a result of the general market increases and the favorable sale of the Eastern Racing Association stock. The important question is not the personal honesty, integrity, or ability of appellants or their proposed management, but rather the lack of balance and equality of control in the capital structure of this trust. Specifically, the court could not feel assured that a recurrence of the events leading up to the present receivership were impossible. Insolvency is likely. Lack of sufficient earnings to cover interest requirements was possible. In such event, nothing would prevent the controlling shareholders, either appellants or their successors, from embarking on new speculation to the detriment of the debenture holders. The court properly felt that debenture holders were entitled now to the cash salvaged from what had appeared to be a doomed enterprise. Finally, it was indicated at the argument before us that one of the appellant's primary motives for the continuation of Aldred was to preserve its security structure, inasmuch as a similar trust could now be created under the Investment Company Act. The Act itself does not require the liquidation or reorganization of existing investment companies which do not conform to the new statutory standards. But when a court of equity has exercised its jurisdiction to appoint new receivers of an investment company pursuant to a complaint charging gross abuse of trust on the part of the trustees or officers, we deem it proper for the court in determining what would be the appropriate remedy in order to afford complete relief to take account of the fact the capital structure is not in conformity with standards and safeguards which Congress has now written into law. That fact, in conjunction with the other facts in the case, may well render it fair and equitable to require the liquidation of the company in the absence of an acceptable plan for reorganization. No dissenting voice to the order of liquidation has arisen for the debenture holders who have the greater equity and whose interests the court was originally called upon to protect. It would seem that, if appellants are intent upon investing in an investment corporation or trust, they could form a new one and even solicit the present debenture holders for subscribers. But it would be inequitable to allow them to force those with burnt fingers to remain investors in an enterprise of proven unquestionable value. In view of the above considerations, we find it impossible to say that the order of liquidation was an improper exercise of equitable discretion, but rather indicated a court of equity doing equity. The decision of the district court is affirmed, and the case is remanded to that court for further proceedings in accordance with our opinion. The end of remedies for tomorrow. Injunctive relief's almost done. We'll be back with conflicts of law in a bit. Have a good break.